it may please, my lords. Serial number 1, 2, 3, all are connected, my lords. And with my lord's permission, if I may refer to serial number 3 appeal, my lord. That is the main appeal of the company, my lord. Other two are the appeals filed by the individuals. So, my lord, on the last occasion of hearing, I submitted before my lords that as far as the impugned order is concerned, it is passed not following the directions directed by my lords. There were 3 specific issues on which my lords remanded the matter back to the Honorable Tribunal to decide these 3 issues. One was with respect to invocation of extended period of limitation. Second was with respect to the use of brand by the assessee and the turnover, because I was claiming small scale industries exemption. And my lord, third is with respect to the, I'm sorry, my lord. So first is invocation of extended period. Second is whether I'm manufacturing branded product or not. And third is the quantum, the turnover, because I was claiming SSI exemption. So the impugned order, my lord, has not complied with these directions, my lord. So if my lords permit me, I'll just refer to the directions given by my lord in the earlier order, my lord, and then the findings given by Honorable Tribunal in the impugned order, my lord. So my lord's order is at annexure 14, page number 260, my lord. Annexure 14, my lord, 14, page number 160, it starts.
160?
260, I'm sorry, my lord. 260. I'm sorry.
Yes.
So, my lord, I'll start with paragraph number 5, my lord. Page 261. So, there were 3 issues, my lord. Paragraph 5. The first issue that arises is as to whether such demand could have been made at all, particularly in respect of the period more than a year prior to the date of the demand. As noticed in the previous order, ordinarily a demand may be made to realize the duty for a period of 1 year from the date that the duty became payable. But an exception is carved out for a demand to be made for an earlier period if it is demonstrated by the department that manufacturer intended to evade duty. So, my lord, as far as section 11A of Central Excise Act is concerned, for issuing a demand notice, it prescribes a normal period of 1 year in case there is no fraud, suppression, collusion with intent to evade duty. There is also a proviso, my lord, which carves out an exception wherein it says that in case there is fraud, collusion, willful misstatement with intent to evade duty, in that case period of limitation of 1 year will be extended to a period of 5 years. In my case, my humble submission is, first, department was supposed to demonstrate the burden of proof that I suppressed material fact from the department is on the department. There are case laws to it, and it is a settled law. And my lord, there is settled law which clearly says that the one who asserts has to prove. In the present case, department is alleging suppression on my part. So it is the burden is on the department to prove that I suppressed. And my lord, starting from the show cause notice, order in original, tribunal's order, nowhere they demonstrate that I actually suppressed any material fact. Therefore, my humble submission is that extended period is not invocable. So I'll make detailed submission because there are so many propositions as far as invocation of extended period is concerned, my lord. And my lord, as far as the direction by my lord is concerned, in para 6, para 7 and para 8, my lords specifically directed the Honorable Tribunal to verify my physical location, because I am not located in the notified area as per area-based exemption notification, then I am not entitled to the benefit which is accruing by being present in the notified area, which is if I pay the duty, I'll be entitled to a refund of the same. So in para 8, my lords have specifically directed, I'll just read, my lord, with aspect of the matter was not taken into consideration whether in the course of the order in original being passed or in the appellate order of the tribunal. This is a question of fact on which there can be no two opinion, and a physical verification is necessary to ascertain whether the manufacturing unit of the appellant falls within the area designated in the applicable notification for the appellant to be entitled to exemption by way of reimbursement. So, my lord, this was the first direction with respect to physical verification. Second, my lord, para 9 is with respect to brand, whether I was actually manufacturing branded product or not. Because if I am manufacturing branded product, the SSI exemption notification will not come to my rescue. If I am not manufacturing branded product, it will come to my rescue, and accordingly benefit will be granted to me. I'll just read para 9, my lord, page 262. The second aspect of the matter on which there is no discussion in the order of appellate tribunal pertains to the disqualification of the appellant to be entitled to exemption on the ground that the appellant manufactured the product under the brand name of another. According to the appellant, it started manufacturing the soya chunks under the Gulab brand name with effect from December 1, 2006. The appellate tribunal has referred to the oral evidence of regular customer of the appellant, which appears to be a rather sweeping statement to the effect that the appellant has always been engaged in manufacturing soya chunks under the Gulab brand. The appellate tribunal placed great credence on such statement, though there was no document in support of the assertion, nor any bill or voucher or like relied upon by the department that would reveal that the appellant had manufactured soya chunks under the Gulab brand prior to 1st December 2006. The appellate tribunal also referred to statements of two Sharma directors of the appellant, but such statements do not reveal the manufacture of Gulab brand by appellant prior to December 1, 2006. And my lord, therefore, in para 10, the my lords have specifically noted that the onus is on the department to establish whether I was actually manufacturing branded product or not. And therefore, they specifically directed that in para 10, my lord, if I may read, when a person claims a benefit under any government scheme and the authorities seek to deny the eligibility of such person to obtain such benefit, the onus is on the authorities to demonstrate why the person would not be entitled to the benefit. As noticed above, it has been the consistent stand of the appellant that it did not manufacture the Gulab brand soya chunks prior to 1st December 2006. It was thus incumbent upon the department to deny the appellant exemption for the period prior to December 1, 2006 only upon cogent material being produced in such regard, whether by way of bills or vouchers or unimpeachable statement or otherwise. But as far as this direction is concerned, I'll just take my lords to the relevant paragraphs of the impugned order, wherein the Honorable Tribunal simply again rely upon those very statements, and they say that these statements are unambiguous without relying on any other corroborative material or document. My lord, I'll take my lords to the statements also. I'll take my lords to the allegation in the show cause notice and the contention in the order in original, which clearly demonstrate that none of these statements very categorically, or let's say very clearly, says that I was actually manufacturing Gulab brand soya chunk prior to December 2006. Right, so this was the second direction. Third, my lord, para 11 If I may read, my lord, para 11, the third issue that requires to be looked into and answered is related to the appellant being entitled to the exemption or not. The wording of the applicable notification exempts a manufacturing unit as an SSI till such time it attains a turnover of 1 crore. In the present case, the initial turnover in 2003-4 was extremely low and same picked up only in 2004-5. In the event the appellant was entitled to exemption as claimed, it requires to be ascertained when the appellant's manufacturing unit exceeded the turnover of 1 crore for the excise duty to be claimed only thereafter. So, my lord, para 12 specifically says that the three key aspects of the matter have not been addressed in the order of the appellate tribunal dated so and so, in the appeal arising out of order in original dated so and so. These issues cannot be conveniently addressed in the present proceedings, which are conducted on summary basis on affidavit evidence. Further, as to whether a person is entitled to an exemption or not, based on the geographical location of the manufacturing unit, is essentially a question of fact that has to be ascertained. And then, my lord, in para 13, my lords have clearly directed the Honorable Tribunal to pass a reasoned order considering these three aspects, my lord. So, my lord, these were the directions by my lords to the Honorable Tribunal, my lord. Now, with my lord's permission, if I may be allowed to refer to the impugned order, my lord, wherein my endeavor is to show that these directions given by my lords have not been complied with by Honorable Tribunal, my lord. My lord, the impugned order is the next annexure 15, page 265, it starts, my lord. So, my lord, annexure 15, page 265. First, I'll deal with invocation of extended period, my lord, how the Honorable Tribunal has given the finding, my lord. If my lord may kindly come to page 300, my lord. Page 300, my lord, paragraph 4.11. This is with respect to invocation of extended period, my lord. May I read, my lord? Para 4.11. So, my lord, now coming to the issue of limitation for making the demand, appellants have contended that they did not have any intention to evade the payment of duty. The crux of their submission is that whatsoever duty they would have paid would be admissible to them in the form of cash refund, as per the notification number 32/1999, which is applicable to them, and the entire exercise is thus revenue neutral. They also submitted that they were under bona fide belief that the goods manufactured and cleared by them were correctly classifiable under the chapter heading 3204 and attracted nil rate of duty. They have submitted a date sheet produced below. So, my lord, it is this short list of dates, my lord. My endeavor here is to show that there are 3-4 proposition basis which I am arguing that extended period is not invocable. One, the entire, first, my lord, the burden to prove that there was suppression on my part, and therefore proviso to section 11A is invocable, the burden is on the department, my lord. And from the show cause notice till the impugned order, department has not come up with any material evidence to show that I suppressed. That is one, my lord. Second, my submission is that department was always in the knowledge that I am manufacturing soya chunks, because, my lord, in the year 2006, and precisely, my lord, on 23rd August 2006, when after the amendment, my lord, I specifically requested the department to ascertain whether the product which I am manufacturing are dutiable or not. For that, my request letter is also there in the appeal paperwork, my lord. And basis my request, on 13th September 2006, department responded saying my product is not excisable, it attracts nil rate of duty, therefore I am not required to get excise registration, my lord. So, my lord, August 2006, I informed very well to the department, and my lord, look at the situation, my lord. In 2008, department comes and issues me a show cause notice. So, my lord, when they had the knowledge of me manufacturing soya chunks in the month of August 2006, what was the occasion for them to come and issue show cause notice in the year 2008, my lord? So, my lord, my second submission is that department was very well aware. My lord, I'll substantiate my submission with respect to case laws also, my lord. I have a compilation to that effect, my lord. I'll just pass over to that. My lord, so that is the second submission with respect to invocation of extended period, my lord. Third is, my lord, that to show that I actually suppressed some material fact and therefore proviso to section 11A of Central Excise Act is invocable, there has to be some positive act on my part intending concealment of material fact with a malified intent to evade payment of duty, which the department was supposed to establish, which they didn't do, my lord, and there is no suppression on my part. So, my lord, that is my third submission. Fourth submission is, my lord, in situations where the assessee is under the bona fide belief that the product he or she is manufacturing is not excisable, suppression cannot be alleged. That is my fourth submission, my lord. Fifth submission is, my lord, which I already submitted before, my lord, that the department was in the knowledge of the entire factual scenario. Therefore, suppression cannot be alleged on my part. So, my lord, basis these 4 points, I'll be arguing the extended period of limitation is not invocable. My lord, I'll just take, my lords, to the relevant case laws, my lord, but before that, I'll just come to the finding, my lord. I'm sorry for digressing, my lord. So, para 4.11, page 300, my lord. After that, my lord, the finding is at 304, my lord. Page number 304, para 4.13. Now, my lord, how the department,
Why did you keep the matter today? Deliberately? To play the fool? Yes.
I'm sorry, my lord. So, my lord, para 4.13, my lord. May, my lord? Now we take for consideration the above arguments, Lord. So those were the reproduction from the relevant portion from order in original, my lord. The Honorable Tribunal did nothing, simply
From the
copied.
tribunal's order, there is a regular appeal to this court.
Indeed, my lord.
And this is that appeal.
This is that appeal, my lord. My lord, this is the second time I am coming to trouble, my lords, because on the first round of litigation, my lords clearly directed the Honorable Tribunal to decide on these 3 issues, my lord. And since the Tribunal could not give specific finding, my lord, therefore I am troubling, my lords, again. My lord, this is the case that where I am manufacturing soya chunks, my lord.
Yes, what is the finding on 11A?
Yes, indeed, Lord. So, my lord, now we take the consideration. Now we take for consideration the above arguments. Commissioner has, in the impugned order in para 3.7, my lord, so there is no independent application of mind by the Honorable Tribunal. They simply refer to the order in original by the Commissioner, my lord. They say Commissioner has, in the impugned order in para 3.7, considered the issue of limitation and have concluded that extended period of limitation can be invoked for making this demand Appellant's contention.
Reading?
I'm sorry, my lord. Page number 304. I'm sorry. Para 4.13.
Yes.
I'll read again, my lord. Now we take for consideration the above arguments. Commissioner has in the impugned order in para 3.7 considered the issue of limitation and have concluded that extended period of limitation can be invoked for making this demand. Appellant's contention is that they were under the bona fide belief that their goods manufactured by them were classifiable under 23.04 and attracted nil rate of duty till the issuance of notification 3/2006 classifying the said goods under 2106/1000 and attracting the duty at the rate of 8%. They relied on the certificate dated 13th September 2006. Well, now, this is a certificate which is issued by the department specifically clarifying that I am not required to take excise registration, my lord. Specifically, I requested to the department if the products which I am manufacturing are excisable or not. Now, how the department responds, my lord? I'll just read the certification, my lord. Page 305. To whom it may concern. This is to certify that Vansha Fragrance Private Limited, address so and so, who manufactures soya nuggets or soya chunk, falling under.
Range superintendent.
I'm sorry, ma'am?
Who is the range superintendent?
My lord, range superintendent.
Why did you approach the range superintendent?
My lord, so what has happened?
No. Is the range superintendent part of the department?
Indeed, my lord, it is. He is.
He is.
He is.
Yes.
He is, my lord. So, my lord, this is to certify that Vansha Fragrance, who manufactures soya chunk falling under Central Excise Tariff heading 2304, as per their declaration, is not a registered Central Excise factory as the product attracts nil rate of Central Excise duty as per tariff and as such is not required to obtain Central Excise registration. Who has clarified this, my lord? Department clarified. When? In 2006, my lord. And before this, my lord, on 23rd August 2006, I wrote a letter to the department, which is at page number, my lord, 128, annexure 4, requesting the department whether I am liable to take registration or not, my lord. Letter dated 23rd August 2006, my lord. Annexure 4, page number 128. And, my lord, the Honorable Tribunal has noted that here also, my lord. It further reads, my lord, page 305. Commissioner has considered this certificate and has recorded his finding on the said certificate. It is interesting to note that Appellant 1 has approached the range superintendent.
Dr. Modika, tell us where has the extended period of limitation been discussed?
My lord, the subsequent portion, my lord, I'm sorry.
Where is the extended period of limitation discussed? What is the finding on that?
Page 305, my lord.
305. What is there at 305? They approached the range officer, who you say is the department. The range officer said it is not required.
Thereafter, my lord, after that, to whom it
read after that.
Commissioner has considered the certificate and has recorded his finding on the said certificate. It is interesting to note that Appellant 1 has approached the range superintendent via his letter dated 23/8/2006, seeking clarification in respect of dutiability of their product, whereas it is their claim that their product became dutiable from 1/3/2006 when notification number so and so dated 1/3/2006 was issued. It is their submission that they had voluntarily approached the department for payment of duty from 1/3/2006. What was purpose for approaching range superintendent on 23/8/2006 when in the understanding of the appellant the product was subjected to duty from 1/3/2006? Further, it is observed that the notification number so and so has been issued under section 5 of the Central Excise Act 1944, which empowers government to grant exemption of the duty leviable, which is excess of the rate specified by the notification. It is also interesting to note that appellant never approached the department seeking any.
How? It approached the department.
Well, approached the department in 2006, my lord.
Yes.
Whereas they started production from 2002.
Maybe. But in 2006, they were told that it's not dutiable.
My lord, if I may just read that certificate once again, my lord. This is to certify that Mrs. So-and-so of so-and-so who manufactures soya nugget, soya chunk falling under central excise tariff heading so-and-so as per their declaration.
The product wasn't soya nugget or soya chunk.
Falling under central excise so-and-so as
What is the product? Is the product not soya chunk?
soya chunk, my lord.
Then, so the declaration goes only as to the description of the product. As per their declaration, is not a registered central excise factory.
As the product attracts nil rate of central excise duty as per the tariff and as such is not required to obtain central excise registration. But they declare, my lord, that they are not
Yes, but
liable.
it was ratified by your department. After ratification, then the paragraph which follows after that certification
My lord.
makes no sense. Rubbish.
My lord, what the tribunal has said, my lord, they started production in 2002.
They
my
may
lord.
have.
My lord.
They came to the department saying that we started production, this is it, we want to pay duty, we seek a clarification. The department said, no, you don't have to pay. So where is mens rea after that? Where is intent to deceive?
My lord, department says on their declaration, my lord.
Yes. But the department said on their declaration, is any part of the declaration wrong?
But they come and assert something, my lord.
Is any part of the declaration wrong? You can say that the certificate is nullified if the declaration they gave to induce the issuance of the certificate was erroneous.
My lord, that is what,
Where is that said?
my lord.
They should write in Hindi if they don't know how to express themselves in English.
But the tribunal says, my lord.
Where has they said that? On the contrary, it says it did not approach the department. The range officer is not a marshal. Range superintendent.
That's true, my lord.
And if he's taken money to issue the certificate, what have we proceeded? How have we proceeded against him? And once 11A goes, everything goes. Look at the logic. Look at the 20 lines that follows the certificate. Commissioner has considered this certificate and has recorded his finding on the said certificate. It is interesting to note that the appellant approached the range superintendent seeking clarification, whereas it is their claim that the product became dutiable.
From 1/3/2006.
1-3. If the product was dutiable, then the range superintendent should have told them. One could have understood that the tribunal says that the declaration furnished was wrong and therefore the opinion expressed was wrong. The certificate was issued erroneously. But that is not the content of this.
That is not, my lord.
Number one. Next. Come to the next part. What was the purpose for approaching the range superintendent? Then last, absolutely no sense at all. It is also interesting to note that the clarification in respect of the dutiability of the product, though they had commenced commercial production clearance from factory 2003, never approached the department, but they approached the range superintendent. They may not have approached the range superintendent or the department in 2003, but they approached in 2006.
My lord.
In 2006, they were advised, no, this is not dutiable. How then is their intent to be penalized? And if you can't go into the extended period under 11A, the rest of the discussion is irrelevant.
And my lord, interestingly, my lord, I'm sorry.
To that extent, my lord, it appears, my lord.
No, because you can't go. The jurisdiction to go is only upon this.
My lord.
Now that's an allegation that you will make in your show cause notice.
My lord.
And they will contest that allegation when the commissioner will consider. Because it's a jurisdictional issue. The commissioner will consider whether that is. Now the commissioner considers it, whatever he writes. Ultimately it goes to the tribunal. It had previously not considered. We specifically require it to be considered. Is this the consideration? We won't send it back over and over again. The rest we don't have to consider. Because this does not satisfy intent. Please place 11A. Is it quoted anywhere in the papers?
Lord, I'll just pass on the relevant portion, my lord.
Not levied, not paid, or short levied, or short paid, or erroneously refunded. Every form.
By the reason of fraud, collusion, any willful misstatement, suppression of facts.
Where duty has not been.
My lord, may kindly come to proviso, my lord.
Within 2 years from the relevant date, serve notice. So that also is other than reason of fraud or collusion or willful, other than, then within 2 years.
I'm sorry, my lord. During the relevant time, my lord, it
Yes.
was 1 year, my lord. During the relevant time.
During the relevant time, it was 1 year.
1 year, my lord.
In 2016, this was substituted.
Indeed, my lord.
1 year.
Indeed, my lord.
Where is the proviso?
My lord, just after that, my lord, if I may be allowed to read, my lord, provided that proviso to section 11A, subsection 1, my lord, provided that,
Just a second, it's
I'm
not
sorry.
there.
I'm sorry. Should I pass it on, my lord?
This was old section 11A.
Indeed, my lord.
What is the period that we are talking about?
My lord, we are concerned with a period starting from March 2003 till January 2007, my lord.
Very good. So this is substituted, this came in 2011.
Indeed.
So you will be entitled to the previous period.
Indeed, my lord.
So your 11A is when any duty has been short to refunded, whether or not such non-levied case may be on the basis of approval accepted within 1 year from the relevant date, serve notice on the person. Then, provided that where any duty or excise had not been levied or paid, or has been short levied or short paid or erroneously refunded by reason of fraud, collusion, or any willful misstatement or suppression of facts, or contravention of any provisions of this Act, or of the rules made thereunder, with intent.
With
With
intent.
intent is superfluous. You have to first demonstrate any of these, and then added to that will be with intent. It's exactly between culpable homicide and murder. I kill a person. All right. But I kill a person is first you have to demonstrate, then you have to demonstrate it was with intent. Over here, first you have to demonstrate that there was fraud or collusion or misstatement or suppression of fact or contravention of provision of the act or the rules. First, you have to show that. And the second is mens rea.
Well,
Where is that? Read that in the 20 lines over there. And this is a specialized tribunal. That's their daily work.
it appears, my lord, they have drawn inference, my lord.
Wait. Show us. That we can also draw that inference. Show us.
Well, it is not said in so many words, my lord, clearly. But
Then unclearly show us how is it said.
well, what in my humble submission tribunal tries to say, my lord, the certificate they obtained from the range superintendent 2006 was a design, my lord, to evade payment.
Very
my
well.
lord.
So I say that I think I am liable to pay duty. But please tell me whether, I'm not sure, please tell me whether I ought to or not. And I disclose all material facts. And then you respond by saying, no, on these facts you don't need to pay duty. Now that, you can fault that only by saying the material facts that I disclosed were erroneous, misleading, false, or like. Or I suppressed any material fact which was relevant for the consideration. There is no allegation to that effect. Forget finding.
My lord, so kindly sees the letter they wrote, my lord, in 2006, my lord. This is at page 128, my lord.
Yes.
What they write, my lord?
No, very good. They wrote that letter. Where is the finding that the contents of the letter are false?
For that finding,
Then, do you have that finding? This is not there.
but my lord, so kindly appreciate this letter, how they write,
No,
my
we
lord.
don't have to. We don't have to. We are in judicial review. Very limited authority over here. On the face of it, you don't disclose. Your order does not disclose compliance with the proviso for 11A to be attracted.
Of course, the tribunal has not dealt with this, my lord.
Not dealt with
But-
it at
but-
all. And this is the only part.
But the fact remains, my lord, their letter itself is misleading, my lord. They claim, my lord, that we are SSI, so we are not liable to pay.
Tribunal ought to have said. Very well, let's go to the commissioner's order. Let's see if the commissioner has said that.
Page 239, my lord, the commissioner's order.
39.
Para 3.7, my lord.
3.7.
Lord, I'm sorry, this is order in original by the adjudicating authority, my lord. Lord, this is order in original passed by the adjudicating authority,
Commissioner's order, my lord.
commissioner's order, not the honorable tribunals,
Not the?
not passed by honorable tribunal, my lord.
No, let's see. This is the order in original.
Indeed, yes.
See, come to the reasons.
My lord.
They adduced a copy of the certificate as mentioned above. I find the plea of the said factory is not sustainable as it is well settled that there is no estoppel against the taxing statute. Now, then, the letter come undertaking dated from the said factory superintendent that the factory has resorted to. That is a conclusion. What is the willful misstatement? Inasmuch as they suppress the fact that they had given an undertaking before the department with a letter dated so and so, obtaining the certificate dated such and such. The undertaking was, however, we hereby undertake that in case any further clarification you or we find falling under central exercise and where is suppression? Where is misstatement? Where is fraud?
My lord, suppression in my humble submission only in the letter, my lord.
Where is the suppression?
But the letter, my lord, so kindly
Thus, we will not hear you. We will look at what the department says. Where does the department say suppression? What is the suppression according to the department? According to the commissioner? Mr. Modika, you write a letter and I say this, or an affidavit, and I say that this affidavit suppresses material facts. That's a conclusion. I first have to say this affidavit does not say this amounts to suppression.
Well,
Suppression is a conclusion.
conclusion.
Where is the instance of suppression before they jump to the conclusion?
The reasoning, my lord,
Where?
is falling
Where?
short, my lord. The reasoning given is falling
Show
short.
us. The benefit of the doubt goes to you. Show us anywhere, unclearly, obliquely, remotely. And that again, we should not go behind the order of the tribunal. Because it was sent back to the tribunal with a specific
My lord.
direction that they should look into that. But sometimes if it has been said before in an appeal, we say that the judge is perfectly right on this finding. We don't have to repeat that. So that's why we are going back to the previous finding. Commissioner has said nothing. These three appeals have been filed under which provision?
35G, my lord. Section 35G of Central Excise Act, my lord.
Under section 35G of the Central Excise Act 1944.
Indeed, my lord.
Full stop.
My lord, if lordship can give me 1 day's time, my lord, maybe Monday, my lord.
Monday all right with
Whether
you?
any action has been taken against the superintendent or not, my lord.
Monday all right with you?
My lord, can it be Friday then, my lord? Otherwise, I'm not from the bar, my lord.
Yes.
I come from Delhi.
Yes.
So maybe next Friday, my lord, subject to my lord's
No, not
convenience.
Friday.
Or next to next Monday, my lord, if that is fine.
Yes, that's all right. Monday week.
I'm here, my lord.
Very well. The department seeks an adjournment. Full stop. On behalf of the appellant, now since counsel for the appellant is not from Shillong, let the matter appear on. Let the matter appear 10 days hence. Full stop. Give a date. Monday week.
10th of July. 12th of June.
That should be 5 and 7, 12.
12th of June.
Only the finding is not recorded, my lord. But the letter they gave, my lord, was
We
very
have to
misleading.
go by that only. We have to go by that.
They claim, my lord, that we are
Too often we say that this is wrong is a conclusion.
my lord.
This is this, therefore it is wrong.
What
That
happened?
middle step, if you skip, it's not adjudication. It's ipsi dixit.
My lord. But the letter is so misleading, my lord. They come and claim that we are SSI,
The
so we are exempted,
letter,
my
the
lord.
letter is mischievous.
My lord.
But a finding had to be rendered. Don't think that we understand the letter is mischievous. But they have to fall within those suppression, misstatement, misleading.
That letter will fall in my humble submission within that
But someone
category.
has to adjudicate that and claim it to
That
be.
finding is not recorded, my lord.
Yes.
Okay.
Item number 4.
May I please, your lordship?
Yes, madam.
The conducting counsel, senior advocate.
What is the matter about, madam?
It is a petition where the petitioner are being aggrieved by the report passed by the 3 members committee headed by the chief.
Yes. This matter has only been adjourned, nothing else. What is it about?
Lordship, this is regarding those tainted teachers which were.
Oh, there is no merit in it.
Lordship.
Prima facie, comma, there does not appear to be any merit in this petition. Paragraph, however, comma, the matter has been deliberately dragged on without any submission being attempted to be made on merits. Full stop. Paragraph, a further adjournment is sought today. Paragraph, the matter will appear peremptorily on next Wednesday's date.
3 weeks, Your Lordship.
The failure on the part of the petitioner to proceed with the matter will result in its immediate dismissal. Don't fool around with us.